Night, with millions of Americans a day away from losing the critical lifeline of SNAP food benefits amid the government shutdown, President Trump is now calling on Republicans to go nuclear. The president posting online, "It is now time for the Republicans to play their Trump card and go for what is called the nuclear option. Get rid of the filibuster and get rid of it now."
Yeah, and they call this the nuclear option for a reason. It's viewed as a last resort even by members of the majority, and it would have the effect of incinerating precedent in the Senate. And so this is a step that even Republicans have been wary to use in the past, but clearly President Trump has made the determination on Capitol Hill at trying to reach a deal to end this stalemate. Now, to be sure, the deal remains out of reach for now, and the president's call to eliminate the filibuster could have the effect of upending those negotiations.
Okay, this is absolutely devastating for Donald Trump, and it's his absolute worst nightmare scenario. Federal courts have ruled that Trump's legal counsel must hand over sensitive documents and transcripts from grand jury investigations. We're talking about files that Trump has been fighting desperately to keep secret, files that contain communications between Trump and his lawyers, files that reveal what Trump knew about classified documents at Mar-a-Lago and when he knew it. And now those files are being unsealed and turned over to prosecutors. This isn't just a minor legal setback. This is the collapse of Trump's main defense strategy, which has always relied on attorney-client privilege and executive privilege to keep damaging information hidden. Judge Beryl Howell issued a bombshell ruling that required Trump associates who have been resisting testifying to appear and respond to investigators. That means people in Trump's inner circle who he thought were protected by privilege claims now have to talk. They have to answer questions. They have to provide documents. And what they're revealing is exposing the inner workings of Trump's legal strategies and his communications in ways that are absolutely devastating to his defense. These aren't just random documents. These are grand jury files that include discussions about Trump's knowledge and intentions regarding classified materials that were kept at Mar-a-Lago after he left the presidency. And crucially, these files directly link Trump to claims that his lawyers submitted to courts and to the National Archives that turned out to be false. That's massive because it potentially shows Trump was involved in making false statements through his attorneys, which could be obstruction of justice or other crimes. But before we go any further, real quick, let's be honest, you can't really trust headlines anymore. That's why we built Pump Politics to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Initiate the nuclear option, says President Trump. I mean, how are leaders likely to react to this? How does this, will this change the dynamic of what was and wasn't happening on Capitol Hill, which is negotiating?
The reality is most Republicans in the Senate are opposed to doing away with the filibuster, and they've been on the record saying this for a long time. In particular, Majority Leader John Thune has been asked about this on multiple occasions and has made it clear that that's not an option that he would like to move toward. So it's not going to be received particularly well in the Senate among Republicans, but it is going to make people uncomfortable.
Prosecutors now have the ability to trace what Trump and his legal counsel knew, when they knew it, and what they did with that information. That's a complete roadmap of Trump's actions and decision-making during the classified documents investigation, and it's the kind of evidence that can make or break a criminal case, because if prosecutors can show that Trump knew he had classified documents, that he knew he wasn't supposed to have them, that he directed efforts to hide them or to mislead investigators about them, and that he worked with his lawyers to submit false information, that's a very strong case for multiple serious crimes, including obstruction and making false statements. The legal battlefield has shifted dramatically in prosecutors' favor. Trump has always relied on claims of privilege to keep this kind of information secret. He's argued that conversations with his lawyers are protected by attorney-client privilege. He's argued that his actions as president are protected by executive privilege. And he's used those arguments to delay investigations, to prevent witnesses from testifying, to keep documents from being turned over. But federal courts have now systematically rejected those privilege claims. They've ruled that the crime-fraud exception applies, which means that attorney-client privilege doesn't protect communications when the lawyer and client are potentially engaged in criminal activity, and they've ruled that executive privilege doesn't shield Trump from criminal investigations into his personal conduct. Those rulings have opened the floodgates. Documents that were hidden are now being unsealed. Witnesses who were refusing to testify are now being compelled to appear, and the evidence that's emerging is reportedly very damaging to Trump's defense. A federal appeals panel specifically overcame Trump's bid to keep classified records secret and allowed the Justice Department to resume its criminal review of the Mar-a-Lago documents. Trump had been trying to block that review by claiming the documents were his personal property, by claiming they were declassified, by claiming executive privilege, but the appeals court rejected all of those arguments. They said, no, these are government records. There's no evidence they were properly declassified. Executive privilege doesn't apply in this criminal investigation context, and they allowed prosecutors to continue their work. That was a huge blow to Trump because it meant the investigation could proceed without the delays and obstacles he'd been trying to create. And now we're seeing the fruits of that investigation as prosecutors dig into these secret files and uncover evidence that links Trump directly to the handling and mishandling of classified materials. Investigators now have access to previously hidden analysis and legal memos detailing Trump's involvement and knowledge about the search for classified files. This is internal documentation from Trump's own legal team and from people in his orbit that shows what he knew, what he was thinking, what he was planning. And that kind of contemporaneous documentation is incredibly powerful evidence because it's very hard to lie about or explain away. If there's a memo from 2 years ago that shows Trump knew he had classified documents and was discussing how to handle them, Trump can't credibly claim now that he didn't know about them or that he thought they were all declassified. The documentary evidence contradicts that defense. The crime fraud exception that allowed prosecutors to pierce attorney-client privilege is particularly devastating because it means prosecutors can demand testimony in secret files from Trump's legal team when criminal activity is suspected. Trump's lawyers are now in an impossible position. They either have to cooperate with prosecutors and potentially provide evidence against their client, or they risk being held in contempt of court or facing their own legal jeopardy if prosecutors believe they were involved in criminal conduct. Either way, Trump can no longer count on his lawyers being a shield that protects information from investigators. That shield has been stripped away by the crime fraud exception, and that fundamentally changes the dynamics of Trump's legal situation. Legal experts are warning that this development could accelerate criminal charges against Trump or trigger new congressional investigations. Because once this evidence becomes available and prosecutors review it, they're going to make decisions about whether to bring charges, and all the reporting suggests the evidence is strong and damaging. So we could be looking at new indictments in the relatively near future, and congressional Democrats who are investigating Trump now have additional ammunition and additional legal grounds to demand testimony and documents. The walls are closing in on Trump in a very real and very visible way. Let's break down exactly what these court rulings mean, what evidence is being exposed, and what the consequences are for Trump legally and politically. All right, let's walk through the legal mechanics of how Trump's privilege claims have been dismantled and what that means for the evidence prosecutors now have access to. We need to start with understanding what attorney-client privilege and executive privilege are and why they've been so important to Trump's defense strategy. Attorney-client privilege is a long-standing legal protection that makes communications between a lawyer and their client confidential. The idea is that people need to be able to speak freely with their lawyers to get effective legal advice, and that requires knowing those conversations won't be disclosed to others. So in normal circumstances, prosecutors can't force a lawyer to testify about what their client told them, and they can't demand documents that contain attorney-client communications. That privilege has been crucial for Trump because much of his planning and decision-making around the classified document situation involved conversations with his lawyers. If those conversations are privileged, prosecutors can't access them, and Trump's lawyers don't have to testify about them. But there's an important exception to attorney-client privilege called the crime fraud exception. If a client is using their lawyer to help commit a crime or fraud, or if the lawyer and client are jointly engaged in criminal activity, then the privilege doesn't apply. The rationale is that the legal system shouldn't protect communications that are themselves part of criminal conduct. And that's exactly what federal judges have found in Trump's case. They've determined that there's sufficient evidence that Trump may have used his lawyers to help obstruct the investigation or to make false statements to investigators, which means the crime fraud exception applies and the privilege is pierced. Judge Beryl Howell's ruling requiring Trump associates to testify despite privilege claims is based on this crime fraud exception. She reviewed evidence that prosecutors presented and concluded that there's probable cause to believe criminal activity occurred and that the attorney-client communications were in furtherance of that activity. That's a very significant finding because it means the judge looked at the evidence and determined it's strong enough to overcome the normally powerful protection of attorney-client privilege. And once that determination is made, witnesses have to testify and documents have to be turned over. Trump can't hide behind privilege anymore. Executive privilege is a different but related concept. It's the idea that the president needs to be able to have confidential conversations with advisors to get candid advice, and that those conversations should be protected from disclosure. Presidents have invoked executive privilege to resist congressional subpoenas, to keep internal deliberations private, to protect national security information. Trump has tried to use executive privilege very broadly to block investigations into his conduct. He's argued that actions he took as president, conversations he had, documents from his presidency, all of that is covered by executive privilege, and therefore investigators can't access it. But courts have been very skeptical of those claims, especially in criminal investigations. The general rule that's emerged from various cases is that executive privilege is at its weakest when it's being used to shield potential criminal conduct. Presidents don't get to commit crimes and then hide behind executive privilege to avoid accountability. And in Trump's specific situation, courts have found that many of the things he's claiming privilege over, like documents he took to Mar-a-Lago after his presidency ended, aren't actually covered by executive privilege at all because they're personal actions, not official presidential duties. The federal appeals court ruling that allowed the Justice Department to resume its criminal review of Mar-a-Lago documents was a major breakthrough for prosecutors. Trump had gotten a district court judge, Judge Eileen Cannon, to initially block the investigation and appoint a special master to review the seized documents. That created months of delay and prevented prosecutors from fully accessing the materials they recovered from Mar-a-Lago. But the appeals court reversed that decision decisively. They said Judge Cannon had overstepped, that there was no basis for blocking the criminal investigation, that Trump's privilege claims were meritless, and they allowed prosecutors to resume their work immediately. That was a devastating loss for Trump because it showed that even judges he might have expected to be friendly to him weren't willing to accept his legal arguments when they were this weak. And it meant all the documents seized from Mar-a-Lago, including classified materials and Trump's own personal records, were now available for prosecutors to review and use in building their case. The specific evidence that's now being exposed through these unsealed grand jury files is reportedly very damaging. According to the reporting, the files include discussions about Trump's knowledge regarding the classified materials. That means there's evidence, probably in the form of witness testimony or contemporaneous documents, showing that Trump knew he had these materials, knew they were classified, and knew he was supposed to return them to the government. That undercuts any defense Trump might try to make that he didn't know what he had or that he thought everything was declassified. If prosecutors have evidence that Trump himself was discussing these as classified materials, that's very hard to overcome. The files also apparently link Trump directly to claims submitted by his lawyers that turned out to be false. This is huge because it suggests Trump was involved in directing his legal team to make representations to the government and to courts that Trump knew or should have known were inaccurate. For example, Trump's lawyers at one point certified to the Justice Department that a thorough search had been conducted and all classified documents had been returned. But the FBI later executed a search warrant and found dozens of additional classified documents. So either Trump's lawyers conducted an incompetent search and certified something they shouldn't have, or someone, potentially Trump himself, was hiding documents and misleading the lawyers, or Trump was aware that the certification was false. Any of those scenarios is bad, but if prosecutors can show Trump was actively involved in providing false information through his lawyers, that's potential obstruction of justice. And that's exactly what these grand jury files are reportedly revealing, the level of Trump's knowledge and involvement in these false statements. Prosecutors are now able to trace the timeline of what Trump and his counsel knew and when they knew it. This is critical for building a criminal case because you need to establish knowledge and intent. It's not enough to show that false statements were made. You need to show that the person knew they were false and made them anyway. And with access to these internal documents and witness testimony, prosecutors can build that timeline. It can show that on a certain date, Trump was told by lawyers or advisors that he had classified documents. Then on a later date, his lawyers made representations that were inconsistent with that knowledge. And if prosecutors can show Trump directed or approved those representations knowing they were false, that's the knowledge and intent element established. That's how you build a rock-solid obstruction case. The crime fraud exception piercing attorney-client privilege has also created a situation where Trump's lawyers are potentially in their own legal jeopardy. If prosecutors believe that lawyers were knowingly participating in making false statements or obstructing the investigation, those lawyers could themselves face charges. That creates enormous pressure on lawyers to cooperate with prosecutors, to tell the truth about what happened, to potentially provide testimony against Trump if that's what the evidence shows. Some of Trump's lawyers have already reportedly cooperated with prosecutors to varying degrees, and each cooperating lawyer provides additional evidence and additional corroboration of the government's theory of the case. Trump can't trust that his legal team is going to maintain solidarity because each lawyer has to think about their own potential criminal liability. That's a nightmare situation for any defendant, but especially for Trump, who has relied so heavily on loyalty from his team. The previously hidden analysis and legal memos that investigators now have access to are also critical pieces of evidence. These are documents that were created at the time events were happening, not reconstructed later for purposes of litigation. That makes them extremely credible evidence. If there's a legal memo from Trump's lawyers discussing the classified documents issue and laying out options for how to handle it, that memo is going to reflect the actual situation and the actual knowledge people had at the time. You can't go back and change it or reinterpret it later to fit a more favorable narrative. It is what it is. And if those memos show that Trump and his legal team knew they had a problem, knew they were supposed to return documents, and were discussing ways to avoid compliance or to mislead investigators, that's devastating evidence that's very hard to explain away. The Mar-a-Lago search itself and the documents recovered there have been central to this entire investigation. The search was executed in August 2022 after months of the government trying to recover classified materials that they knew Trump had taken when he left office. Initially, the National Archives asked for materials back. Trump's team negotiated and returned some boxes. But the government had evidence that more classified materials remained at Mar-a-Lago. They tried to get Trump to return everything voluntarily. When that didn't work, they obtained a search warrant. The search recovered over 100 classified documents, including some at the highest classification levels involving national security secrets. The sheer volume and sensitivity of the materials contradicted representations Trump's lawyers had made. In the locations where documents were found, including in Trump's personal office and storage areas, suggested they were being kept deliberately rather than accidentally overlooked. All of that contributed to the Justice Department's decision to pursue a criminal investigation. And now, with access to these grand jury files and internal Trump communications, prosecutors can build out the full story of how those documents ended up at Mar-a-Lago, why they weren't returned when requested, what efforts were made to hide them or mislead investigators, and what Trump's role was in all of that. The legal experts warning that this could accelerate criminal charges are basing that assessment on the strength and clarity of the evidence that's apparently now available. Building a criminal case takes time because you need to investigate thoroughly, gather all relevant evidence, interview witnesses, analyze documents, build a coherent narrative that proves each element of the charged crimes beyond reasonable doubt. But once you have the evidence in hand, once you've done the investigation, and you know what happened, the timeline for charging decisions speeds up considerably. And from all indications, prosecutors are now at or approaching that point where they have the evidence they need and they're making decisions about charges. That's why we're seeing reports of Trump's legal team in panic mode because they know what's coming. The potential for new congressional investigations is also significant because Democrats in Congress have their own oversight responsibilities and their own interest in understanding what happened with classified materials and presidential records. If criminal charges are brought, Congress will likely want to investigate the broader implications for presidential accountability and for safeguarding classified information. And the evidence that's now available through these court rulings will inform and support congressional investigations. Democrats can subpoena witnesses, demand documents, hold hearings, all based on the factual record that's being established through the criminal investigation. So Trump is facing legal jeopardy on multiple fronts, criminal prosecution and congressional oversight, and they're reinforcing each other as evidence becomes available. Let's break down the key implications of counsel accessing these secret files and what it means for Trump going forward. Point 1, the complete collapse of Trump's privilege-based defense strategy. Trump's entire approach to resisting the classified documents investigation has been built on asserting various privileges, attorney-client, executive, presidential immunity to keep evidence hidden and witnesses from testifying. That strategy has now comprehensively failed. Courts have systematically rejected his privilege claims, found that the crime fraud exception applies, allowed prosecutors to access documents, and compel testimony. And once that happens, once the shields are stripped away, Trump is left defending on the merits of the facts and the law. And apparently the facts are very bad for him. He can't hide behind privilege anymore. He can't delay through procedural litigation over access to evidence. The evidence is now available, and prosecutors are using it. That's a fundamental shift from playing defense about whether prosecutors can see certain things to playing defense about what those things actually show. And the latter is a much harder position for Trump because the evidence apparently directly contradicts the narratives he's been trying to push. Point 2, the exposure of Trump's knowledge and intent. Criminal cases, especially white-collar and obstruction cases, often hinge on what the defendant knew and what they intended to do. It's not usually enough to show that bad things happen. You need to show the defendant knew about them and acted intentionally rather than mistakenly or negligently. That's typically the hardest part of a prosecution to prove because knowledge and intent are internal mental states. But Trump's situation is different because prosecutors now have documentary evidence and testimony that apparently shows what Trump knew and when. If there are documents showing Trump discussing the classified materials as classified, that proves knowledge. If there are communications showing Trump directing his lawyers to make certain representations, that proves intent and involvement. If there are timelines showing Trump was told about obligations to return documents and then took steps to avoid returning them, that proves knowing violation. All of that makes the prosecution's case dramatically stronger, and it makes Trump's defense dramatically harder because he can't credibly claim ignorance or mistake when there's contemporaneous evidence of his knowledge and intent. Point 3, the legal jeopardy Trump's lawyers now face and what that means for cooperation. The crime fraud exception finding means that Trump's lawyers are potentially at risk themselves If prosecutors believe they knowingly participated in criminal activity, that creates enormous pressure on those lawyers to tell the truth and to cooperate with prosecutors. Because if a lawyer thinks they might be charged, the calculation changes from protecting the client at all costs to protecting themselves. And the way to protect themselves is to cooperate, to provide truthful testimony, to potentially testify against Trump if that's what the evidence shows. We've already seen some of Trump's lawyers cooperating to various degrees, and each cooperating witness corroborates and strengthens the government's case. Trump can't count on lawyer loyalty when those lawyers are facing their own potential prosecution. That's a huge problem for him, because lawyers know everything. They know what really happened, what was really discussed, what decisions were really made, and if they're telling prosecutors all of that truthfully because they're trying to save themselves, Trump is in deep trouble. The normal attorney-client relationship, where the lawyer zealously advocates for the client and keeps everything confidential, has broken down in Trump's case because of the crime-fraud exception, and that breakdown is devastating to his defense. Point 4, the timeline toward potential charges and what that looks like. Legal experts are warning this could accelerate charges, and that makes sense based on where the investigation appears to be. Prosecutors have been working on this for over 2 years at this point. They've gathered extensive evidence through the Mar-a-Lago search, through subpoenas, through witness interviews, and now they have access to the additional evidence from these newly accessible documents and compelled testimony. At some point, prosecutors have to make a charging decision. Do we have enough evidence to prove crimes beyond a reasonable doubt? Do we believe we can get a conviction? Is prosecution in the public interest? All the reporting suggests prosecutors believe the answer to those questions is yes. They have the evidence, they can prove the crimes, and there's significant public interest in holding a former president accountable for mishandling classified information and potentially obstructing an investigation. So we could see charges brought in the relatively near future, and those charges will likely include obstruction of justice, making false statements, improper retention of classified documents, and potentially other crimes depending on what additional evidence prosecutors have. Each of those charges carries serious penalties, including potential prison time, and the combination of multiple charges creates significant criminal exposure for Trump. Point 5, the political implications and how this affects Trump's standing. Being charged with federal crimes, especially crimes involving classified information and obstruction of justice, is going to be politically devastating for Trump. He can try to spin it as political persecution, as a witch hunt, as the deep state trying to take him down, and his hardcore base will probably believe that narrative. But for moderate voters, for independents, for Republicans who aren't fully in the MAGA camp, seeing Trump indicted on serious federal charges backed by extensive evidence is going to be very damaging. It validates concerns about Trump's fitness and judgment. It makes him look like a criminal rather than just a controversial political figure. And it makes Republicans who continue to support him vulnerable to attacks about being associated with someone who's literally under federal indictment. The political fallout from charges could be substantial. Trump's opponents will use the charges extensively in campaigns. Democrats will argue that Republicans are supporting a criminal defendant for president. Moderate Republicans might start distancing themselves from Trump to avoid being tainted by association, and all of that weakens Trump's political position and the Republican Party's overall electoral prospects. The charges would also dominate news cycles for weeks or months, drowning out any other message Trump or Republicans are trying to deliver. That's a huge problem in the lead up to 2026 elections. The bottom line, the access that counsel now has to Trump's secret files represents the worst nightmare scenario that Trump has been fighting desperately to prevent. His privilege claims have been dismantled. His defense strategy has collapsed. Evidence of his knowledge and intent is now available to prosecutors. His lawyers are facing pressure to cooperate, and some apparently are. The timeline toward charges is accelerating, and the political damage is mounting. Trump is in the most serious legal jeopardy of his life. The evidence that's being exposed apparently shows him knowing about classified documents, directing efforts to retain them, misleading investigators, making false statements through his lawyers. All of that adds up to multiple serious federal crimes. And prosecutors now have the evidence they need to prove those crimes beyond a reasonable doubt. Trump can't hide anymore. The secret files are being opened. The truth is coming out. And the consequences, both legal and political, are going to be severe and lasting. We're watching the walls close in on Trump in real time. The nightmare he's been trying to avoid is now happening. And there's no clear path for him to escape the accountability that appears to be coming. This is a defining moment in Trump's legal saga and potentially in American political history. A former president facing serious federal criminal charges based on strong evidence that he mishandled classified information and obstructed justice to cover it up. The outcome will shape precedents for presidential accountability and will have massive political ramifications for years to come.